Hey gun owners, are you thinking about signing up in the Right to Bear self-protection program? I got their contract right here, so stand by for my analysis. Hey guys, Attorney Marc Victor here. I'm the owner and president of the Attorneys for Freedom law firm. Today I want to give you my analysis of the Right to Bear Self-Defense Liability Protection Program. So let me start with Section 8. It says limitations and exclusions. And I thought this part was very interesting. Paragraph A, I'm going to read from it verbatim. Here's what it says. This agreement is not an insurance policy, and the services provided for herein are not insurance. Definitely not insurance. However, if you look at every page of the Right to Bear contract, what you'll find in the top right, it says Moultrie Insurance. Why are they listing an insurance company on the top right of every page of their contract if it's not insurance? By the way, I checked out Moultrie Insurance. They've been in business since 2021. All right, so take that for whatever it's worth, but definitely not an insurance product. I'm not thinking it was an accident that they included the insurance company on every single page of their contract. But if you look at member services 24/7, membership not available in New Jersey, New York, and Washington, exactly the same states that don't allow these types of insurance products in their state. Definitely not insurance. Now I'm looking at Section 3A, subsection 3. And I want to read from that section right here. It says legal representation by a contracted lawyer in the defense of any legal proceeding arising from lawful weapon use by the associate in the applicable state. Why do you think they say lawful weapon use in that section? And I'm going to subsection E. Here's what it says verbatim. This agreement specifically excludes, and neither the association nor any contracted lawyer shall have any liability or obligation to provide any legal representation or other services or any benefit or coverage hereunder arising out of or in connection with. Okay, so I read that verbatim. And then I get into E1. Any incident or legal proceeding involving lawful weapon use, unless at the time of such lawful weapon use, the associate was in lawful possession of the applicable firearm or other lawful weapon, and the associate was in a location where possession of such firearm or other lawful weapon by the associate was legally permitted. Okay, this is a pretty standard exclusion across the board, right? If you're not lawfully in possession of the weapon, or the incident happens somewhere where that weapon is prohibited. Remember, there are many such places: government buildings, schools, polling places, other, quote, sensitive areas. Your incident happens there. It certainly seems from a reading of subsection E1 here, no coverage for you. Again, this isn't any problem at all with the Attorneys on Retainer program. We don't have those listed as exclusions. Looking at Section 2, any incident or legal proceeding for conduct that is not directly and specifically related to lawful weapon use by an associate for which justification is available as a defense under applicable law. But in addition, if you go down to subsection E4, I'm going to read verbatim from that section. Again, these are things that are excluded. Any incident involving a firearm or other lawful weapon against current or former family members, household members, domestic partners, romantic relationships, or similar relationships of any associate, unless in a posture of legal self-defense as the victim of the incident, period. Okay, I can't tell if domestic violence issues are excluded or included from reading this paragraph. I don't know what that means. You're going to have to decide for yourself. You want to be sure about it. Attorneys on Retainer, doesn't have any such exclusion for domestic violence. Also look at subsection 6. Any circumstance in which providing such legal representation or other services or other benefit or coverage hereunder would be contrary to public policy or illegal. Why do you think they're talking about contrary to public policy or illegal? I don't know, but I can tell you that insurance companies don't get to provide coverage for illegal acts. Also take a look at section F, subsection 2. The associate is engaged or allegedly engaged in criminal or other illegal activity. Allegedly engaged? Well, if you're charged with a crime, you are allegedly engaged in criminal or other illegal activity. Now, to be fair, I don't know how Right to Bear is going to interpret any of these sections, but it certainly seems like they have every right to say it's a bad shoot. And if it's a bad shoot, we can't cover it. And that, of course, wouldn't surprise me because no insurance company can cover a bad shoot. Call them and ask them. Say, hey, what happens if I'm in a bad shoot? Will you still cover it? Or is that excluded? I'm going to guess here, but probably it's excluded. Don't take my word for it. Read the contract for yourself. They don't cover illegal acts. Okay, lawyer selection. Check out section 9. It's entitled Administration, Legal Services by Contracted Lawyers. Take a look at section B. Here's what it says. All legal services shall be provided by contracted lawyers, which shall be independent third-party lawyers. The association is not a law firm and does not provide legal advice or services. Okay, well, no surprise there. You're not dealing with a law firm. You're dealing with either an insurance company or some kind of a membership club, Right to Bear. But they're pretty honest here in telling you they're not a law firm. They don't provide any legal advice or services. But if you look at the bottom of that same paragraph, the last sentence, here's what it says. All complaints about the legal services provided, professional misconduct, or claims based on legal services provided by a contract lawyer must be addressed solely with the contracted lawyer and the state bar of the applicable state and not with the association. All right, that seems pretty clear. You got a problem with the lawyer? Don't talk to Right to Bear. Talk to the lawyer or the state bar. But then it continues. Section C. Each associate shall have the right to select the contracted lawyer of his or her choice when legal services are needed out of the contracted lawyers made available by the association under this agreement. Okay, so it seems they've got a bunch of contracted lawyers. Who are these lawyers? What are their credentials? We don't know. But you certainly get to select from that group. But they're very clear in this contract. You don't have to go with one of their pre-selected contracted lawyers because that same paragraph continues. Here's what it says. In addition, any associate shall have the right at any time to retain counsel of his or her choice authorized to practice in the applicable state other than a contracted lawyer made available under this agreement. Okay, that's good, but then it continues. Provided that in such case, such associate's counsel, and then it has in parentheses, must adhere to the association's predetermined agreed upon fees, end parentheses, shall be responsible for all fees, costs, and expenses of such counsel and shall receive no reimbursement for such from the association under this agreement. Okay, let me confess, I don't know what that means. It seems like it's saying, well, you can pick a lawyer, but that lawyer's got to adhere to the association's predetermined agreed upon fees. I wonder what those fees are. I wonder if they're planning to pay top dollar for an experienced lawyer. I don't know. My hourly rate is $6.50 an hour normally if you want to hire me off the street. Ask them if they'll pay $6.50 an hour for an experienced criminal defense lawyer. Maybe they will. I don't know. But there's no information in the contract about what those fees are, and not all lawyers charge the same fees. But then there's all this language about being responsible for fees, costs, and expenses of such counsel and shall receive no reimbursement. I don't know what any of that means. I'm just pointing this out in the contract. Maybe contact Right to Bear and ask them, or just read it for yourself, but it certainly seems very confusing to me in terms of who your lawyer is going to be in the event you have a problem, an emergency, and you need to talk to somebody right now. Maybe we shouldn't be surprised, because right in paragraph A of Section 9, they tell you right from the beginning, the services under this agreement shall be administered by the association and or certain third parties selected by the association. All right, not clear at all to me from reading this who your lawyer is going to be. Yes, they have a 24/7 emergency hotline. Ask them if the lawyer you speak to on that hotline is the same lawyer who's going to be representing you if you get into a self-defense incident. So Right to Bear, to be fair, not the worst. They have some good coverages. They have some things that they include. Fantastic, but not the best in our opinion either. What's the best? The attorneys on retainer program. Why is it the best? Because instead of dealing with a club that has an insurance company listed on every page of their contract, why not deal directly with a law firm? So when you call 24/7, 365, and you get a lawyer on the phone, that lawyer is going to be part of the legal team of lawyers who will be actually defending you if you have a legal incident that arises that gives rise to criminal charges. And very importantly, I know you think you'll never be in a bad shoot, but you don't get to choose the time and place. What if the incident happens at 2 o'clock in the morning and you're awakened from a deep sleep? What if the incident happens somewhere else? You maybe had a few drinks or something and you're not at your best. You might not make the best decision. With the Attorneys on Retainer program, even if it turns out that it's not a good shoot, as long as you reasonably and in good faith intended to act in self-defense, you're covered. Why can we do this? Because while insurance companies can't cover criminal acts, criminal defense law firms can. So if you're in a bad shoot, as far as I can tell, we're the only show in town. And you might be in a bad shoot, right? I mean, imagine a really good shoot. Okay, well, really good shoots that are very clear usually don't yield criminal charges. What if it's a questionable shoot? Okay, if it's a questionable shoot, my guess is the people over at Right to Bear are going to cover you so long as it doesn't fall into one of the exclusions. But what happens if you plead guilty? Like 95% plus of the people do in the criminal justice system. Do you lose your coverage? I don't know. Do you lose your civil coverage with Right to Bear? I don't know. What I do know is you don't with the Attorneys on Retainer program. And of course, if it's a bad shoot, if it's the kind of shoot where you say, you know, I acted and I thought was self-defense, I thought I was defending myself, but it turned out maybe what we call imperfect self-defense. Maybe the threat against which you were acting was not an imminent threat. Maybe you made a mistake. You threatened or used deadly physical force to protect property. Okay, everyone might conclude it's a bad shoot. If you're part of the Attorneys on Retainer program, we'll still represent you, no problem. Check us out online. attorneysforfreedom.com. You can learn about the Attorneys for Freedom law firm. You want to know more about AOR? Check the red button. You can go directly to the Attorneys on Retainer website. It's just attorneysonretainer.us. Everything you want to know about the Attorneys on Retainer program is right there. You can sign up very easily online. If you have questions, reach out. We're happy to answer any questions you have. If you like this video, like and subscribe at the bottom. You got comments, good or bad. We answer all civilized comments. Again, don't take my word for any of this. Read the contract for yourself. My name's Marc Victor. Thanks for listening. Peace.